Good, whenever this is. Not legal advice. Like, subscribe. Please like and subscribe. Please share. Please comment. I do like and I do read all the comments, so please do so. Share with your pets, your plants, and whoever else you want to share with. Thank you for watching this. It's always appreciated. Do not rely upon anything that is said. What I wanted to talk about a little bit about today is yesterday, JR and I did two live streams about the oral argument in the Supreme Court involving the Jarkesy case. And I thought it was pretty complicated art stuff to follow. So what I'm going to try to do is in a couple of minutes, I'm going to try to summarize what I thought happened and how it plays into Alpine and FINRA. And before I go from there, I refuse to believe that my road worker father was stealing from his job. But when I got home, all the signs were there. All the signs were there. Okay. I speaking of that, I have an inferiority complex, but it's not really a very good one. And last but not least, people say I'm condescending. That means I talk down to people. Anyway, not legal advice again. This is SEC versus Jarkesy. And just so we get the context, it was in the Supreme Court yesterday argued. It had been in the lower courts. In the lower courts, the finding that the actions of the SEC against Jarkesy were that they were unconstitutional. So the SEC brought the appeal. That's how the action got to the Supreme Court. A lot of this case discussed the Atlas Roofing case, which was a case long ago decided in the Supreme Court about 50 years ago, where it was decided that if the government goes after you for a fine, there's no right to a jury trial under the Seventh Amendment of the Constitution, which guarantees a jury trial. By the way, let me distinguish first of all between a civil right and a criminal right. So, in a matter involving a criminal case, you do have an absolute right to a jury trial. We're talking about the right to a jury in a civil proceeding. That's what this is. So, the basic question that was at the heart of Jarkesy versus the SEC, again, those are the parties involved, was the extent of what extent could the regulatory system, what did it have to do in terms of affording a defendant or an accused with a jury trial in federal court? When did that have to happen? And obviously, the SEC operates now like it doesn't have to happen, has the option. It can initiate a proceeding against a member for money within the SEC system, or it could do so in the court system. It has the option. So the question here was whether it is proper for it to have the option, or whether everything has to first go to the court system, or as even I think the Jarkesy counsel said, maybe just giving people the option of which system they would go. So the question is, what kind of claims brought by the government triggered the right to a Seventh Amendment right to a jury trial? And in such situations, the adjudicatory system of the SEC would not be the proper forum for that trial. So just to kind of briefly discuss the facts of Jarkesy. So Jarkesy got penalized in an enforcement action by the SEC. He was fined $300,000 and was also directed to return profit of something like $635,000, and it was for a statutory securities fraud claim against him. So there was reference to 10b-5 claims, etc. So the rule basically exists, or the way the court was deciding, that if it's a new regulation and a new claim and new right, that would not be something someone would be entitled to a Seventh Amendment right to a jury trial. But if it was a claim that arose like the claims back in 1791 in Old England basically for fraud. So if you defrauded somebody back then, you could file a claim for fraud, and you'd have to prove up certain elements. And that claim for fraud, we call that a common law claim. And there may be some other claims. I was thinking maybe negligence also, but there's certain elements and certain claims that existed back then, independent of statutes and regulations. And you can't also take something that's like common law fraud, convert it into a statutory fraud, and say it's not a common law claim. So, which was also discussed. But anyway, the issue arose because of the fine portion. So it was the fine portion brought by the SEC that triggered really this case and the argument. And that's where the court really focused all of its attention, to be honest, on the Seventh Amendment and the issue of the fine. So this doesn't appear, Jarkesy, in my opinion, doesn't appear to be a case where the court is set upon completely throwing out the entire SEC system. It appears more of, and this is just based on my view of the oral argument, appears to be a situation where the court is going to remove the regulatory powers one petal at a time, like in a rose, just one power at a time. And first they're looking at the right to a jury trial and whether the SEC should have the right to adjudicate these kind of cases within their own system. And the conservative justices, I would say, which form the majority, were very skeptical about that and about whether the government has the right to offer someone some set of rights and somebody else similarly situated with a different set of rights. Seems to me, my speaking, seems capricious, arbitrary, doesn't really make a lot of sense. So, based on that, and based upon the finding, it appears to me they're going to say that the claims against Jarkesy were equivalent to common law fraud. Same elements, in fact, even though that the securities fraud will require less proof, in the action that was filed, they actually filed it using the elements of common law fraud. So it was broader. So I think it's very possible, based upon the questioning by the court, and even by the response by the attorney for the government at one point in time, that the court will find against the SEC and limit their power. Will they limit their power completely? I mean, it's possible. Could they throw out the entire regulatory system of the SEC or the adjudicatory system? It's possible. I don't think so. Is it possible they make a rule that when any common law claim is filed by the SEC, that they must first offer the right to adjudicate that before a jury in federal court? Could say that. They might say just fraud claims survive, or fraud claims and negligence claims. But I think they're going to be narrower in terms of a decision. So as opposed to eliminating the SEC's power to adjudicate all matters, they're going to start off limiting certain claims, and those claims will be shifted outside of the SEC. And I think that's how it will go. And perhaps maybe every year or two, there'll be new cases that come on involving other regulatory bodies, and they'll keep on peeling back the powers. But what I found was interesting, and I'm shifting to FINRA and Alpine, during the hearing. So that was how I believe the case in Jarkesy is going to come down, that the court will order some limitation on the SEC's ability to handle certain claims without the right to a jury. But during the hearing, and especially the minority, so this is the party that I think is going to vote in support of the SEC in Jarkesy, but they were talking about if it was a non-governmental situation. So here in Jarkesy, it's the SEC, which is governmental, versus a private individual. But the two liberal justices who spoke the most, they said that if, in fact, as opposed to the government, we were talking about two private parties, that would be a much harder case, that the right to a jury trial would be much more likely, and this is just talk, would be much more likely to attach when you're talking about two private individuals as opposed to when the government was involved. And I was thinking of Alpine and FINRA, and FINRA asserts and is a private company. All the SROs, so those are those companies, corporations that work in line with the government but aren't the government, are private companies, and they continuously assert that fact that they're private. On top of that, they get immunity, so they're private with immunity. So the fact that the court and the justices that would be more likely to support the government action indicated that if a private company is involved, I think should cause concern to FINRA. And what I think is likely is that if the court, and I'm just speculating now, but if the court in Jarkesy rules along the lines I've indicated, so they limit the SEC's power, I think it's very likely that one of the three cases now in the DCC circuit involving FINRA, not the SEC, may be up in the Supreme Court in the next year's term in terms of the scope of what FINRA can do. And I know there's at least three cases. There are also enforcement cases. They also involve fines, etc. I think it's very likely that one of those cases, or maybe all three, will be up some point in time in 24, 25. And I think it's very likely, especially if they rule in favor of Jarkesy, I think it's very likely that the court would limit FINRA's powers of enforcement even more so than they do the SEC, because the SEC is part of the government. And when I suspect that there may be a limitation of the immunity that's provided to FINRA, because why would FINRA private have immunity? To me, it doesn't make sense. It gives them a special power that other private companies do not have. And I think that's a risk that they are facing now. So I thought the decision involving Jarkesy put FINRA, or let me back up. I think the potential decision in Jarkesy, but the discussion in the oral argument, if I were counsel for FINRA, I'd be concerned. I think it's very possible that very soon FINRA is going to lose its power. And on top of that, I think they run the risk of having their immunity either restricted, limited, or changed. And if their immunity was restricted or changed, for example, when I sued and others sued FINRA regarding MMTLP, for example, they couldn't have asserted immunity as defense. We would have been able to go forward in a lawsuit and get discovery. So I think that potentially is a giant change forward for retail. We're not there yet because we first have to get through Jarkesy, but I could see the writing on the wall, and I think that's also why in the Alpine appeal, why there were like 40 briefs filed. I think other parties believe there's a decent chance that Alpine might end up before the U.S. Supreme Court, and the powers of FINRA and all SROs might be up. Now, despite that, the court in its discussion said nothing that should give Alpine any solace that they're going to escape from this nonsense. There was nothing that said, for example, that the enforcement actions to protect the public, that those had to be before an Article 3 court with a jury trial. Nothing like that. It was very specific to the monetary claims. So if FINRA is out there trying to protect the public and wants to eliminate Alpine's ability to do business, I think it's a much better argument that they can do that within their own system as opposed to going to federal court. It's only the issue of seeking fines like occurred in Jarkesy. So I would urge FINRA today, and I urge them every time I speak to them on these stupid videotapes, tomorrow, either go into federal court and shut down Alpine, or two, sever the damage part. In other words, you have a proceeding to get rid of Alpine for the public benefit. You also have had monetary claims. Dump the monetary claims for now. Pursue those in federal court if you want to. But the most important thing is shutting down Alpine. There was nothing in that Supreme Court hearing that said you can't do that. Nothing. So if I was Alpine's counsel listening to the oral argument yesterday, they had no good news for their scumbag clients. The only thing that changed, and the only thing I would say is, listen, scumbag client, the only issue that we're talking about related to Jarkesy and if you go up to the Supreme Court is whether you get put out of business by the SEC and FINRA or you get put out of business by the federal courts. That's the only thing that might be an issue. Otherwise, you're out the door. So that's my review of that. Interesting. I think again, oral argument was interesting. I think Jarkesy is going to win some kind of victory, and I think the language of the hearing put FINRA at risk because it's a private company, and because even the minority justices realize that where you have private entities, the right to Seventh Amendment even more attaches than when the government's involved. So it'll be interesting to see how this develops, and I hope that explained some things. If any of this or all of it didn't make sense, please comment, write questions, and I'll try to clarify it. But again, I think it's going to end up being limitation of the SEC with a potential future limitation of FINRA, probably even more so, but no impact directly on Alpine. And in fact, I would say just go ahead and get rid of Alpine. Anyway, have a great day. Be well. Hope it's clear. And again, any questions, please throw them at me. Have a great day.